Trump's DOJ move to crush Obamacare, approves appeals court decision. The Justice Department notified a federal appeals court that it approved an appeals court decision stating the entire Obamacare statute is unconstitutional. Back in December 2018, a Texas judge ruled that the Affordable Care Act, otherwise known as Obamacare, was unconstitutional. U.S. District Court Judge Reed O'Connor wrote, "The Department of Justice has determined that the district court's judgment should be affirmed. Because the United States is not urging that any portion of the district court's judgment be reversed, the government intends to finally brief on the appeal schedule." The decision came in the case of Texas v. Azar, in which the constitutionality of the individual mandate was disputed. O'Connor said that Justice John Roberts referring to Obama attacks was no longer applicable because Congress terminated the fines placed upon people who did not obey the individual mandate. So the invalidity of the individual mandate, the essential part of Obamacare, made the entire package invalid. Trending, Mitch McConnell Mueller report exonerates Trump but not Obama. Flowing O'Connor's decision, he wrote, "Here, the plaintiffs allege that, following passage of the Tax Cuts and Jobs Act of 2017, TCJA, the individual mandate in the Patient Protection and Affordable Care Act, ACA, is unconstitutional. They say it is no longer fairly readable as an exercise of Congress's tax power and continues to be unsustainable under the Interstate Commerce Clause. They further urge that, if they are correct, the balance of the ACA is untenable as inseverable from the invalid mandate." O'Connor continued, "Resolution of these claims rests at the intersection of the ACA, the Supreme Court's decision in FIB, National Federation of Independent Business v. Sebelius, and the TCJA, Tax Cuts and Jobs Act of 2017. In FIB, the Supreme Court held the individual mandate was unconstitutional under the Interstate Commerce Clause but could fairly be read as an exercise of Congress's tax power because it triggered a tax. The TCJA eliminated that tax. The Supreme Court's reasoning in FIB, buttressed by other binding precedent in plain text, thus compels the conclusion that the individual mandate may no longer be upheld under the tax power. Indeed, because the individual mandate continues to mandate the purchase of health insurance, it remains unsustainable under the Interstate Commerce Clause, as the Supreme Court already held." O'Connor delineated how the defendant's position was inconsistent at the threshold. The intervener defendants hope to have their cake and eat it too by arguing the individual mandate does absolutely nothing but regulates interstate commerce. That is, they first say the individual mandate does not compel anyone to purchase insurance. HRGTR. At 37 hours 12 minutes. Yet they ask the court to find the provision regulate commerce. Among the several states. U.S. Const. Art. 1, Section 8. CL. 3. The intervener defendant's theory, then, is that Congress regulates interstate commerce when it regulates nothing at all. But to regulate is to govern or direct according to rule and to bring under the control of law or constituted authority. O'Connor noted, "The court today finds the individual mandate is no longer fairly readable as an exercise of Congress's tax power and continues to be unsustainable under Congress's interstate commerce power." All told, Congress stated 3 separate times that the individual mandate is essential to the ACA. That is once, twice, 3 times and plainly, on the unambiguous enacted text alone, the court finds the individual mandate is inseverable from the act to which it is essential. The ACA's text and the Supreme Court's decisions in FIB and King thus make clear the individual mandate is inseverable from the ACA. He concluded, "For the reasons stated above, the court grants plaintiffs partial summary judgment and declares the individual mandate, 26 U.S.C. Section 5000 A, unconstitutional. Further, the court declares the remaining provisions of the ACA, Pub. L. 111-148, are inseverable and therefore invalid." Neonedal.com web link.